The Supreme Court has unanimously denied emergency review to the issue of concealed carry bans and defiance of their Bruen decision. But not all hope is lost, so let's break down what is happening. Now, really quick before we jump into this video, I want to thank one of the main supporters of this channel, which is 1st Phorm. 1st Phorm's an amazing company. They have great supplements, protein powder, pre-workout, all that stuff that I use when I work out. I cannot recommend them enough if you're trying to get healthier and trying to work out some more. But also one of the amazing things about them is they're pro-freedom, pro-America, and they support the Second Amendment and what we do here on the channel. So if you're interested, check them out using the links down below. And if you order something $50 or more, you can get a free 4-pack of energy drinks. Now, as I mentioned in the intro, in this video, we need to talk about some of the recent Supreme Court actions when it comes to CCW permits and the recent unanimous decision by the Supreme Court, which essentially denied emergency review to this critical issue of concealed carry bans. You may recall that recently the Supreme Court granted, vacated, and remanded a case called Antonyuk back down to the Second Circuit for a new decision in light of what they said in the Rahimi case, which was an 8-1 decision. The Antonyuk case challenged New York's new hyper-restrictive concealed carry ban, which was passed through the Concealed Carry Improvement Act, and that was passed just 8 days after the Supreme Court issued the Bruen ruling. The Second Circuit issued a new decision on the concealed carry bans, finding that Bruen was an exceptional case, and because of that, the same type of analysis did not need to be applied with the new carry permit law, which was passed in New York. Now, that ruling by the Second Circuit was then elevated once again to the Supreme Court on an emergency basis, but the Supreme Court then decided to deny review to that emergency application. However, this issue is not done. There is still another long shot case in front of the Supreme Court on an emergency basis, seeking review of a carry ban in Hawaii, and this case will proceed forward at the lower court level. Now, this issue of concealed carry bans has been going on for a long time, and it really ramped up after Bruen. Recently, the Second Circuit ruled in 5 of those CCIA cases, and they ruled and reviewed the preliminary injunctions. The Second Circuit ultimately vacated the lower court's rulings, finding that the good moral character determination does not violate the Second Amendment. In that decision, the Second Circuit distinguished these cases from Bruen, and they said that Bruen was an exceptional case, and these ones weren't. In response to the Second Circuit's rulings, GOA then filed a second petition for emergency Supreme Court intervention. Although this case was still in an interlocutory posture, the Supreme Court did GVR the case in light of what they said in Rahimi. Now, after the Supreme Court GVR'd Antonyuk back to the Second Circuit, you would think that the Second Circuit would get the message and at least attempt to faithfully apply the review and the analysis in Bruen and also try to look at the case in light of Rahimi. But of course, they did not. Instead, they wrote a 246-page opinion essentially saying that Rahimi changes nothing. Ultimately, the Second Circuit gambled and went with defiance once again, and they were hoping that the Supreme Court would not actually take action on their analysis because it was still in an interlocutory posture. New York argued to the Supreme Court that the Supreme Court did not need to grant review or get involved in the case at this time. The main thrust of their arguments were that this case is still too early for Supreme Court review, that they don't need to step in, that the state should be allowed to rely on later history to justify these restrictions, and that the plaintiffs do not have standing to actually challenge some of the provisions within the CCIA, like the good moral character determination that's included with this law. In arguing that the case is too early for Supreme Court review, New York stated that, as an initial matter, this court's ordinary practice of denying interlocutory review is especially advisable here, where the Court of Appeals merely found that plaintiffs did not establish a likelihood of success on the merits at the preliminary injunction stage, either for a lack of standing or for a lack of meritorious legal claim. So New York argued that the best course of action for the Supreme Court was to simply punt the case and not get involved at this time. Finally, they walked out kind of the old standing issue that they bring up quite often. They argued that none of the plaintiffs have applied for the new permit and they've not been denied based on the moral character determination, so they don't have standing to bring this challenge and it's not a valid claim. And it appears that the Supreme Court agreed with New York. In the order list, the Supreme Court denied review in this case. It was unanimous. None of the judges, there was no dissent. No one wrote an opinion dissenting on this issue. Now, this seems to kind of be one of the more consistent approaches right now when it comes to the Supreme Court, where they want to avoid any interlocutory cases, and that kind of seems to be the mode they're currently in. There have been some occasions where the Supreme Court would get involved on an interlocutory basis, GVRing some of these cases like they did in Antonyuk, or even when they issue denials, there'll be some sort of dissent from someone like Thomas or Alito, but here in this denial, there was nothing. Now, the denial order in this case from the Supreme Court is not the end of the road when it comes to the Antonio case or this issue of concealed carry bans. The Antonio case will now head back to the lower court, to the district court for a final merits decision. The parties right now are instructed to set deadlines for this case so they can move it towards a final merits decision. The Antonio case will have the unfortunate uphill battle with the Second Circuit's precedent sitting right now, where Bruin in its application is only for exceptional cases. So they're going to have to get over that hurdle in the lower court because the lower court is going to be bound by what the Second Circuit said. I will say that the lower court judge, Judge Sotheby, has been very fair when it comes to, reviewing this issue. He is a New York District Court judge, so take that for what it is. But when it came to reviewing this case, it seems at least like he's being in some ways fair, and he did find that the good moral character determination within the CCIA is invalid when it comes to Bruin. Now the game will be to get the final merits decision as fast as possible and elevate it through the circuit courts and eventually get it back to Supreme Court. The other wrinkle of this issue is that currently there is looming review in another concealed carry ban case out of Hawaii, and that is in the Wolford case out of Hawaii. Wolford is a little bit different from Antioch, even though they deal with a similar law in carry structure that was passed after Bruin. Wolford deals with the Ninth Circuit upholding the state's catch-all public property restrictions, and so that's why it's a little bit different. Unlike the Second Circuit, the Ninth Circuit found in Wolford that states and their public property bans, those outright restrictions are permissible since the state of Hawaii allows property owners to give different forms of consent when it comes to concealed carrying at those locations. Hawaii allows permission through signs or verbal consent, and so therefore the Ninth Circuit found that that was more permissible than just outright bans. I will say, however, that the Wolford case is still a long shot, especially because it's still a preliminary injunction review, and the Supreme Court's current mode of operation, like I mentioned, is to deny those types of reviews. At least that is the course that they've taken when it comes to 2A cases. They've been granting emergency reviews in other cases dealing with the Trump administration, so they have no problem stepping in at a preliminary injunction stage or interlocutory cases when it comes to other issues, but when it comes to 2A cases, they've avoided them like the plague. Also want to note that maybe the Supreme Court's looking at some of the actions from, people like the DOJ and AG Bondi, where they've sent out notices to local, areas like the LA County saying that you need to issue permits, and if you don't, we're going to investigate you and look at the defiance that you're doing in regard to Bruin. So maybe that's something that's also going to come to New York, and maybe the Supreme Court is just relying on the administration to enforce Bruin instead of them doing it themselves. Now, there is still one other option, although I will also say it's a long shot, and that comes through the efforts to pass the National Concealed Carry Reciprocity Bill. That bill recently passed through the House Judiciary Committee, and it will move forward to a full House vote that hopefully will happen soon. That bill will have a hard time passing the Senate without a lot of help and maybe something else happening because, again, it has to get over the filibuster. However, if it did get through, that would open up the door for residents in states like New York and states like California to get non-resident permits in other states, maybe more permissible states. And then the hope would be to force the main state like New York or California or others to recognize those out-of-state permits. As of right now, these lower courts don't have to worry about the Bruin analysis or the Supreme Court stepping in to enforce it or to correct their incorrect statements down below, because again, the Supreme Court has just been inactive on this issue. My biggest fear is that we would end up in a cycle like we did after Heller, where you go 14 plus years of inactivity by the Supreme Court, where they don't step in, they don't strike down defiance from lower courts, and eventually it takes a big landmark case to correct the issue, but then they go inactive once again. So hopefully we don't end up in that unfortunate situation, and hopefully the Supreme Court takes action in at least some cases, maybe like Snope or State Tactical dealing with rifle bans and magazine bans. And in those decisions, they correct a lot of the issues when it comes to the Bruin analysis in defiance of the lower courts. As we get more information, as things develop when it comes with these concealed carry issues, I will let you guys know. Also, if you like this video and you like to support the channel, one of the best ways to do that is to like, comment, and subscribe. All those things help to fuel the algorithm, and it signals to YouTube that you guys see value in these videos and in this type of 2A news. But as always, thank you all for watching. Don't forget to like, comment, and subscribe. And never forget, this nation was built by armed scholars, and this nation will be maintained by armed scholars.